Hey everybody, time to go again.
Two, three, four.
Hey, it's that time again, folks. Well, it's time for something a little different. A large article on the doctrine of inevitable discovery, a plea for reasonable limitations by Stephen P. Grossman. So, for those who aren't familiar with the doctrine of inevitable discovery, it's an exception to the exclusionary rule, which allows the exclusionary rule was protection for violations of defendants' Fourth, Fifth, and Sixth Amendment rights by police malfeasance, police doing illegal shit. And that made it so that if the police did illegal shit in obtaining evidence, a confession, or otherwise doing some fuckery, that a court would then exclude that evidence that was wrongly gained from trial. Now, the doctrine of inevitable discovery is kind of an end around that's gotten way out of control, according to this author and myself as well. And we're going to review this law journal article wanting some limitations on the reach of the law of inevitable discovery. All right. Introduction 1. In reinstating the Iowa murder conviction of Robert Williams, the Supreme Court accepted explicitly for the first time the doctrine of inevitable discovery. Applied for some time by state and federal courts, the doctrine of inevitable discovery is a means by which evidence obtained illegally can still be admitted against defendants in criminal cases. Unfortunately, the court chose to adopt the doctrine without any of the safeguards necessary to ensure that the deterrent impact of the exclusionary rule would be preserved, and in a form that is subject to and almost invites abuse. This article warns the danger to fundamental constitutional protections posed by the open-ended approach taken by the Supreme Court into the doctrine of inevitable discovery in Nix v. Williams. Then recommends a means of applying the doctrine so as to accomplish its purpose of avoiding unwarranted exclusion of probative evidence without significantly diluting the impact of the exclusionary rule. 2. Brewer v. Williams. The disappearance of the 10-year-old Pamela Powers from YMCA building in Des Moines, Iowa on Christmas Eve of 1968 set off a chain of events which culminated in two major and highly controversial Supreme Court decisions separated in time by 7 years. In order to comprehend the rationale and approach of the Supreme Court to the doctrine of inevitable discovery, it is first necessary to summarize the known facts surrounding the death of Pamela Powers. A short time after Pamela Powers' disappearance, Robert Williams, an escaped mental patient residing at the YMCA, asked a 14-year-old boy to help him load a large bundle wrapped in a blanket into his car. The boy later reported that extending from the bundle, he had seen two legs that were, quote, skinny and white, close quote. The next day, Robert Williams' car was located in Davenport, a city 160 miles east of Des Moines. Shortly thereafter, articles of clothing, which police believed belonged to Pamela Powers, and an army blanket, similar in appearance to the one used to wrap the bundle Williams had removed from the YMCA, were found at a rest stop on Interstate 80, approximately 60 miles east of Des Moines. These facts led police to suspect Williams had murdered the Powers girl and disposed of her body somewhere between Des Moines and the rest stop where the articles of clothing and the blanket were found. The police then obtained an arrest warrant for Robert Williams and began a large-scale search for the child's body in the vicinity of the rest stop. On December 26, while the search was underway, Williams, after speaking with attorneys, surrendered himself to the police in Davenport. He was given his Miranda rights, charged with murder, and arraigned before a judge. Arrangements were then made to transport Williams, accompanied by two detectives, back to Des Moines by car. An agreement was reached between the police and Williams' attorneys that no questioning of Williams would occur during the ride. Both Williams and Detective Lemming, who was to accompany him, were made aware of this agreement. On the car ride back to Des Moines, however, Detective Lemming delivered the now famous Christian burial speech to Williams, in which he told Williams of the need to locate the child's body before the Iowa winter snows covered it up and prevented the girl from getting a proper Christian burial. Detective Learning reportedly said the following to Williams, quote, I want to give you something to think about while we're traveling down the road. They're predicting several inches of snow for tonight, and I feel that you yourself are the only person that knows where this little girl's body is. And get if you get snow on top of it, you yourself may be unable to find it. And since we'll be going right past the area where the body is on the way into Des Moines, I figured that we could stop there and locate that body. That the parents of the little girl should be entitled to a Christian burial for that little girl who was snatched away from them on Christmas Eve and maybe murdered. After some more discussion between the two, Williams eventually led Lemming to the site of the child's body. Based largely on the above facts, William was convicted of murder in the first degree for the death of Pamela Powers. After his appeal was rejected by the Iowa Supreme Court, Williams sought habeas corpus relief in the United States District Court for the Southern District of Iowa. The District Court reversed his conviction, and the decision was affirmed by the United States Court of Appeals for the Eighth Circuit. The United States Supreme Court affirmed the Eighth Circuit in order that Williams be retired. The court, or retried, or that Williams be retried, I'm sorry, not retired. The court found that the statement that Detective Lemming had obtained from Williams during the ride from Davenport to Des Moines violated Williams' right to counsel under the Sixth Amendment. Because Williams had been arraigned, the formal judicial process had already commenced, and he was fully protected by the Sixth Amendment. The court determined that the speech Lemming made to Williams was a deliberate elicitation of information from Williams, and therefore was a violation of Williams' right to counsel under the holdings in Massai versus United States. Readers of this opinion could not help but be drawn to two other parts of the Supreme Court's decision. One was a particularly bitter dissent by the Chief Justice, beginning with, quote, "The result in this case ought to be intolerable in any society who purports to call itself an organized society." It was the same Chief Justice who had later authored the opinion in Williams 2 that, in the end, avoided this intolerable result by applying the doctrine of inevitable discovery. The second item of note in Williams 1, not related directly to the Sixth Amendment issue at hand, was the hint contained in the footnote at the conclusion of the court's opinion given to those who would ultimately determine the judicial fate of Robert Williams. Quote, "While neither Williams' incriminating statements themselves nor any testimony describing his having led the police to the victim's body can constitutionally be admitted into evidence of where the body evidence of where the body was found and of its condition might well be admissible on the theory that the body would have been discovered in any event, even had incriminating statements not been cited from Williams." It was, in fact, the doctrine of inevitable discovery alluded to in this footnote which became the vehicle to which evidence obtained from the victim's body was admitted against Williams at his second trial. 3. Fruits of the poisonous tree doctrine. In order to assess the worthiness of the doctrine of inevitable discovery and to understand the parameters within which it should operate, the doctrine needs to be analyzed in its proper context. Such an analysis necessarily includes a discussion of the purposes of the exclusionary rule, the fruits of the poisonous tree doctrine, and the exceptions to this doctrine, among which is the doctrine of inevitable discovery. The rule which excludes illegally obtained evidence from use by the prosecution in a criminal case has traditionally been justified in two ways. First, it is argued that the use of evidence obtained in violation of a law by courts charged with enforcing that law would threaten the integrity of the judicial system itself. This concept, known as the principle of judicial integrity, has been viewed with increasing disfavor by the Supreme Court in recent years. Instead, it is the purported deterrent impact upon the police produced by suppressing illegally obtained evidence that is cited most often today as a justification of the exclusionary rule. This deterrent impact is intended not only for the offending officer, but for all officers who in the future might consider engaging in the same improper conduct. Bearing in mind that deterrence is currently perceived to be the primary justification behind the exclusionary rule, it is important now to assess the extent to which the exclusionary rule is applied. The exclusionary rule has been applied by the Supreme Court to what has been called secondary or derivative evidence as well as primary evidence. That means that whether the illegal conduct of the police officer leads directly or indirectly to the discovery of evidence, that evidence will be suppressed providing there is a causal link between the original illegality and the evidence sought to be used. For example, A is illegally arrested, confesses following this illegal arrest, and implicates B as a source of his narcotics. If the police then enter B's house, seize the narcotics, and ultimately use them in a prosecution against A, the narcotics will be suppressed due to the fact that discovery stems from the original illegality committed against A. Such a derivative or secondary evidence has been called the fruit of the poisonous tree. The exclusion of such illegally obtained or derivative evidence will result whether the evidence stems from an illegal search or seizure under the Fourth Amendment or a statement taken in violation of the defendant's right under either the Fifth or Sixth Amendment. Because the exclusionary rule operates to prevent the prosecution from using probative evidence against defendants in criminal cases, and the perception among many that guilty people often go free because of this exclusion, the exclusionary rule has been the subject of much criticism. In an effort to ameliorate both the actual and perceived impact of the exclusionary rule, the Supreme Court has limited its application. Specifically, where the court has determined that the deterrent impact upon the police of applying the exclusionary rule in a specific situation is minimal, the court has been reluctant to apply the rule. When the evidence at issue is derivative, the court has been particularly sensitive to the concern that the cost to society of applying the exclusionary rule exceeds the benefit achieved by the deterrent impact of the rule. As a result, the court has fashioned several exceptions to the principle that evidence which is the fruit of the poisonous tree must be excluded. In 1920, the court created the independent source exception to the exclusionary rule. Stated simply, the independent source exception provides that when the discovery of information or evidence is achieved by both illegal means and through an independent legal source, the evidence will not be suppressed. This exception, according to the Supreme Court, stems from the principle that the police should not be put in a worse position than they would have been had they not committed the illegality. For example, in a situation where narcotics are seized after the police learn of their location, both through information obtained from an illegal statement by a defendant and through information learned from a witness whom they discovered legally, disallowing the use of that narcotics at trial would be putting the police in a worse position than they would have been had they not obtained that illegal statement from the defendant. 19 years after outlining the independent source exception in Silverthorne, the court identified another situation where the exclusionary rule should not be applied to derivative evidence. In Nardone v. U.S., the court held that evidence may be admissible even when the discovery is linked exclusively to police illegality. The court in Nardone concluded that when the discovery of evidence occurs under circumstances that suggest that the effect of the original illegality has become attenuated or weakened, the causal chain between the illegality and the discovery of the evidence may be deemed to have been broken. In such situations, the evidence would no longer be considered tainted and would therefore be admissible against the defendant. The court had an opportunity to explain the application of this attenuation doctrine in the 1968 case of Wong Sun v. U.S. In Wong Sun, the Supreme Court held that although verbal evidence can be the fruit of a poisonous tree and therefore suppressible, suppression will not result automatically, even when a causal connection can be shown to exist between the original police illegality and the discovered evidence. Expressed differently, the court determined that merely because the evidence in question would not have been discovered but for the illegality does not mean exclusion will automatically result. Instead, courts should look to, quote, whether granting establishment of the primary illegality, the evidence to which instant objection has been made has been come at by the exploitation of that illegality or instead by means sufficiently distinguishable to be purged of that premium taint. Following his illegal arrest, Wong Sung made a statement to the police that he sought to have suppressed by his product of his illegal arrest. The court noted that because Wong Sung had been freed after the arraignment, had been returned voluntarily several days later to make his statement, quote, the connection between the arrest and the statement had become so attenuated as to dissipate the taint. Specifically, Wong Sun's several days of freedom after his illegal arrest and other events preceding his giving of the statement to the police had so weakened the lingering effects of his illegal arrest that it was unreasonable to say that the confession resulted from an exploitation of that illegal arrest. The third exception to the fruits of the poisonous tree doctrine has been applied by some state and federal courts for years, but was never explicitly accepted by the Supreme Court until its 1984 decision in Nix v. Williams. Known as the doctrine of inevitable discovery, this exception allows for the admission of evidence whose discovery derives from a police illegality, but which the police can show would likely have been discovered eventually by legitimate means. Therefore, although the challenged evidence is linked causally to an illegality and no attenuation has occurred, the police are given the opportunity to demonstrate hypothetically that the evidence would have been discovered by some legal means in the future had the illegality not occurred. In order to understand and assess the doctrine of inevitable discovery as outlined by the Supreme Court, it is necessary to pick up the story of Robert Williams after the Supreme Court reversed his conviction in 1977. Part 4. Supreme Court Acceptance of the Inevitable Discovery Doctrine, Williams 2. At Williams' second murder trial in 1977, the prosecution introduced evidence obtained from the body of Pamela Powers, which was located as a direct result of the illegal statement obtained from Williams by Detective Lemming. The theory behind the trial court's decision to omit this evidence was that the body would have been discovered ultimately by a police search which was well in progress at the time that Detective Lemming obtained the statement from Williams. In other words, the doctrine of inevitable discovery. In affirming Williams' second conviction, the Iowa Supreme Court approved the trial court's use of the doctrine of inevitable discovery to allow evidence derived from the body to be used at Williams' trial. Referring to the doctrine as the, quote, hypothetical independent source exception to the exclusionary rule, the Iowa Supreme Court concluded that the necessary elements embodied in this exception were met in the Williams case. These elements were: 1, that the police did not act in bad faith for the purposes of hastening the discovery of the evidence in question, and 2, that the evidence in question would have been discovered by lawful means. With respect to the first element of the doctrine, the Iowa Supreme Court concluded that because there was a substantial disagreement over the validity of Detective Lemming's interrogation among judges well versed in criminal procedure at every level of the appellate process, quote, it cannot be said the actions of the police were taken in bad faith, close quote. Regarding the second element of the doctrine, the Iowa Supreme Court concluded that by a preponderance of the evidence, the state had shown that without the illegality obtained statement, the ongoing police search would have turned up the body of Pamela Powers before its condition had materially changed. In 1981, Williams' request for a writ of habeas corpus was denied by the United States District Court for the Southern District of Iowa. The District Court agreed with the Iowa Supreme Court that the doctrine of inevitable discovery had been correctly applied by the trial court in the case. 2 years later, however, the United States Courts of Appeals for the Eighth Circuit reversed the denial of the writ. The Eighth Circuit accepted arguendo the Iowa Supreme Court's statement of the elements necessary for prosecutorial use of the inevitable discovery doctrine, but disagreed with the Iowa Court's conclusion that the lack of bad faith requirement had been met in this case. Specifically, the Eighth Circuit rejected the Iowa Supreme Court's reliance on the debate among judges to demonstrate a lack of bad faith, instead focusing on what it believed to be the intent of Detective Lemming when he obtained the statement from Williams. Because the Supreme Court had concluded in 1977 that Lemming had deliberately, designedly, and purposely elicited the incriminating statements from Williams, and Lemming had not testified at the state suppression hearing regarding his state of mind in taking the statement from Williams, the prosecution had failed to meet its burden of showing that Lemming's actions were actually taken without bad faith. Accordingly, the Eighth Circuit found it unnecessary to consider whether the state court finding regarding the likely discovery of the body through legal means was supported by the record, or even whether the preponderance of the evidence standard adopted by the state court was the appropriate standard. Reversing the Eighth Circuit, the Supreme Court held in Williams 2 that there was indeed an exception to the exclusionary rule known as the doctrine of inevitable discovery. But the proper application of the doctrine did not depend on the showing of a lack of bad faith on the part of the police. Therefore, the Iowa court felt it unnecessary to enter the debate between the Iowa Supreme Court the Supreme Court felt it unnecessary to enter the debate between the Iowa Supreme Court and the Eighth Circuit concerning whether Detective Lemming's interrogation of Williams was not only illegal, but also conducted in bad faith. Instead, the court ruled that where the state can show by a preponderance of the evidence that the evidence discovered as a result of police illegality would likely have been found eventually through legal means, that evidence is admissible in the state's case in chief. Prior to the court's holding in Williams 2, there was a debate among courts commentators about the wisdom of such a hypothetical independent source doctrine. Proponents argued that society was being punished disproportionately when courts suppressed illegally obtained evidence that was probative when it would inevitably have been discovered through legal means. Opponents objected to the speculative nature of the doctrine and its likely effect on encouraging improper police shortcuts to the detriment of the exclusionary rule's goal of deterring such behavior. At Williams 2, however, the court decided upon an application of the doctrine which was limited only by the likelihood of discovery. As to this one limitation, the court imposed the lowest burden of proof conceivable. In defending its decision to apply the inevitable discovery doctrine in the forum, the court drew support from its prior decisions concerning derivative evidence and the fruits of the poisonous tree doctrine. The court correctly referred to its prior holdings in Silverthorne and Wong Sun for the proposition that evidence which is derived from a police illegality need not always be suppressed by the fruits of the poisonous tree doctrine. Specifically, the quote quoted from Wong Sun saying as follows, quote, "We need not hold that all evidence is the fruit of the poisonous tree, simply because it would not have come to light but for the illegal actions of the police. Rather, the more apt question in such a case is whether granting establishment of the primary illegality, the evidence to which instant objection is made has become, by its exploitation of that illegality, or instead by means sufficiently distinguishable to be purged of the primary taint. This paragraph shows the view of the Wong Sun Court that the existence of a causal connection between illegal police conduct and the discovery of evidence does not automatically require the suppression of that evidence. Instead, courts should look to whether the police exploited the illegality or recovered the evidence through other means that are sufficiently remote as to be purged of that illegality. The court in Williams II, however, went far beyond the interpretation of the above passage and discerned that Wong Sun Court, quote, thus pointedly negated the kind of good faith requirement advanced by the Court of Appeals, close quote. In adopting the inevitable discovery exception without a good faith prerequisite, the court found support for its position in the independent source exception to the exclusionary rule's derivative evidence principle. The derivative evidence principle, according to the court in Williams II, rests on the notion that society needs to deter police from gaining any benefit from their illegal conduct, whether that benefit was direct or indirect. To accomplish that deterrent purpose, derivative evidence acquired as a result of an antecedent illegal police practice is not usable by the government, even though that evidence is probative on the issue of the defendant's guilt. On the other hand, the court observed, the application of the independent source exception ensures that the prosecution will be put, quote, in no worse position because of some earlier police error or misconduct. According to the court, this principle of putting the police in the same positions they would have been in had the illegality not occurred achieves the proper balance between competing societal interests of deterring police impropriety and having jurors receive all probative evidence. Since, in its opinion, the inevitable discovery doctrine and independent source doctrines have a functional similarity, the court maintained that, as well as with the independent source doctrine, the no worse off principle should be applied to considering the breadth of limitations of the inevitable discovery doctrine as well. In a recent article, Professor Watterson and Merton have taken issue with the court's grafting of the no worse off principle onto the exclusionary rule. They note that in those cases which created and fleshed out the independent source rule, such as Silverthorne, the court never relied on a no worse off justification, but instead emphasized there was an independent source which leads to the discovery of evidence. No exploitation of legality in fact occurred. Further, if the no worse off rule is interpreted to mean what it seems to say, the court is communicating to the police that there is no real price to be paid for illegal conduct, no matter how flagrant or how purposeful, and regardless of how serious a specific constitutional right might be affected. When another source of discovery exists, it is not difficult to see how this principle would materially diminish the deterrent impact of the exclusionary rule. Even if one accepts the court's questionable grafting of the no worse off concept onto the independent source rule, the court's assertion that the no worse off concept would therefore automatically be applicable to the inevitable discovery doctrine is unpersuasive. Without analysis, the court discerns a functional similarity between the independent source and the inevitable discovery doctrines, which logically compels the application of the no worse off rule to the inevitable discovery doctrine. The no worse off rule then serves as a justification for the court holding that the question of whether the police acted purposefully or flagrantly in committing their illegal activity is irrelevant to the issue of whether the inevitable discovery doctrine applies. A closer examination of the doctrine of inevitable discovery reveals that it is different from the independent source rule in a fundamental way, and in fact is way more properly compared to another exception to the exclusionary rule's derivative evidence principle, attenuation. Once it is understood how inevitable discovery doctrine is fundamentally similar to the attenuative exception, it then follows that, as with the attenuation doctrine, courts considering application of the inevitable discovery exception should assess the purposefulness and flagrance of police misconduct. As the court noted, the independent source exception is not applicable to the facts of Nix v. Williams, since the sole source of the discovery of the Power Girl's body was the illegal statement obtained by Williams. While the independent search for the girl's body may have ultimately discovered the body, whether it actually would have is clearly a hypothetical question. Although the court noted and then quickly passed over this distinction, it is an essential one in any exclusionary rule analysis. While there is no causal link between the police illegality and the ultimate discovery of secondary evidence in question, because the police use a source independent of the illegality to uncover the evidence, the exclusionary rule is inapplicable. When there is such a causal link, the derivative evidence principle of the exclusionary rule applies, but it then becomes necessary to determine whether the need to exclude the evidence is overcome by countervailing factors. Such a situation exists, for example, when the effect of an illegal police action upon the ultimate discovery of evidence is attenuated to such a degree that the deterrent purpose of the exclusionary rule would not require the suppression of the derivative evidence. Where this causal connection exists, courts typically focus on whether there has been an exploitation of the legal process illegal police conduct in determining whether the evidence acquired should be excluded. An examination of the existence and degree of exploitation necessary includes an assessment of the intent of the police officer and the degree of the opprobrium that should be attracted to the police activity involved. Using the Fourth Amendment as the subject, Judge Charles Moylan has explained the distinction between a situation in which the principle is inapplicable and one in which it may deem to have been satisfied. Primarily, this difference reflects a distinction between defining the limits of the principle on one hand and describing its value on the other. Although the ultimate result of finding that the Fourth Amendment is inapplicable is the same as finding that the Fourth Amendment is satisfied, that is, the evidence is admissible, the reasoning which leads to this result is quite different. In Judge Moylan's words, quote, "When the Fourth Amendment is satisfied, constitutional liberty is vindicated. God is in his heaven and all is right with the world. Involved is a matrix of values, including such fine things as warrants, oaths and affirmations, particularity of description, probable cause, exigency, good faith on the part of the police officer, and the sanctity of thresholds. When, however, the Fourth Amendment is inapplicable, good and evil have no relevance." Similarly, the independent source exception can be viewed as a situation in which the exclusionary rule is inapplicable because there was no causal connection between the illegality and the discovery of the evidence. Both the attenuation and the inevitable discovery doctrines, on the other hand, are examples of the exclusionary rule satisfied in that the illegal police conduct involved in each does not lead to the discovery of the challenged evidence, but other factors relevant to the purposes behind the exclusionary rule may result in overcoming the need to suppress the evidence. In its treatment of the attenuation doctrine, the Supreme Court has consistently acknowledged the importance of looking into the intent of the police officer and the nature of his illegal conduct. There are two reasons why the fact that an officer committed an illegality purposefully and in a flagrant manner will be relevant to any analysis of whether the doctrine of attenuation should be applied to the facts of a given case. First of all, the more flagrant and purposeful the police conduct is, the less likely it is that the impact of the conduct upon the defendant would be weakened. For example, in a situation in which a defendant challenges a confession that is obtained after an illegal arrest, the details surrounding that illegal arrest concerning bad faith, purposefulness, and flagrance of the police conduct would be important factors. The more outrageous the police conduct in effecting the illegal arrest, the more likely it is that the impact of that illegality would still be felt by the defendant at the time he makes his statement, and therefore the less likely it is the impact of the illegality would be attenuated. The second reason why courts and commentators have looked to the flagrancy and purposefulness of police wrongdoing in attenuation cases is because such conduct impacts directly and significantly on the deterrent purposes of the exclusionary rule. In Brown v. Illinois, the Supreme Court considered the admissibility of a statement made following an illegal arrest and after the proper administration of Miranda warnings. The court noted that, quote, "If Miranda warnings by themselves were held to attenuate the taint of an unconstitutional arrest, regardless of how wanton and purposeful of the Fourth Amendment violations, the effect of the exclusionary rule would be substantially diluted. In holding that statement to be a fruit of the improper arrest, the court in Brown relied to a significant extent on its conclusion that the intent of the officers in Brown affecting the arrest was to elicit the very statement at issue. Furthermore, Justice Powell pointed out in his concurring opinion that where the illegal police conduct is flagrant, the need for the deterrence achieved by the application of the exclusionary rule is more acute. In Taylor v. Alabama, both of the 5-justice majority and the 3 justices who joined O'Connor's dissent agreed that flagrancy and purposefulness of the police conduct is an important fact in determining whether the defendant's statement was a fruit of her illegal arrest. The issue in United States v. Castiglione was whether the testimony of a witness discovered through an illegal search could be said to be sufficiently unconnected to the illegal search so that the attenuation exception would apply. After discussing the difference between live witnesses and inanimate objects for purposes of applying the fruits of the poisonous tree doctrine, the court noted that the officer's illegal search was committed without the intent to find such a witness. The court concluded that absent such an intent, there would be no detriment impact in suppressing the witness's testimony. When the prosecution seeks to have evidence admitted through the doctrine of inevitable discoverability, it is understood that, as with evidence sought to be introduced through the attenuation exception, the discovery of the evidence in question was derived in fact from the knowledge gained through the illegal piece activity. Therefore, as with the attenuation doctrine, and unlike the independent source rule, consideration of the inevitable discovery doctrine presumes that the exclusionary rule is applicable. If evidence is ultimately admitted based on the inevitable discovery exception, as with the attenuation, and unlike the independent source rule, the exclusionary rule, although applicable, has been satisfied. In assessing whether the exclusionary rule has been satisfied, courts should consider all the relevant purposes, values, principles, and balancing factors that accompany that rule, and then apply it to the facts of any case they have at hand. Unfortunately, in adopting this version of the inevitable discovery doctrine in Williams II, the court concluded that any time the challenged evidence would more likely than not have been discovered even without the illegal police conduct, quote, the deterrence rationale has been so little basis that the evidence should be received, end quote. For those who might doubt this assertion, the court continued, quote, anything less would reject logic, experience, and common sense, close quote. The court's conclusion that there is never a benefit to be derived from excluding illegally obtained evidence once the prosecution can show the likelihood of ultimate discovery through a lawful means is a most significant one. The result of such a conclusion is that courts will essentially ignore illegal police activity that may be both purposeful and flagrant. In other words, if the prosecutor can convince a judge that evidence more likely than not would have been discovered even without the illegal police conduct, it is immaterial to the admissibility of that evidence that the police knowingly violated the defendant's rights in order to uncover that same evidence. In refusing to require courts to do a case-by-case assessment of the need to deter, as demonstrated by purposefulness and flagrant police misconduct, before applying the inevitable discovery doctrine, the court not only rejects the comparison to attenuation cases, but additionally ignores a significant aspect of recent exclusionary rule cases. As a concept of deterrence has become the prime justification for the exclusionary rule, the court has consistently examined the nature of the wrong and the purposefulness of the police misconduct. Only recently, the court ruled that, at least in warrant cases, the determining factor in the decision whether to exclude evidence obtained in violation of the Fourth Amendment is whether the police acted in good faith. In other words, evidence will be suppressed if the police purposefully avoided the requirements of the Fourth Amendment in obtaining a warrant or should have known that the warrant they acted upon was in fact deficient. Given the Supreme Court's inclination to look at both the purposefulness and the flagrancy of police illegality in exclusionary rule decisions, and the significance of these two factors in accomplishing the deterrent purpose of the exclusionary rule, it is important to analyze the court's justification for eliminating consideration of these factors with respect to application of the inevitable discovery doctrine. In Williams II, the court specifically rejected the Eighth Circuit's conclusion that, quote, if an absence of bad faith requirement were not imposed, the temptation to risk deliberate violations of the Sixth Amendment would be too great and the deterrent effect of the exclusionary rule reduced too far, end quote. The court reasoned that an officer who has the opportunity to acquire evidence illegally will seldom be able to determine at that time whether the evidence sought would be discoverable inevitably through legal means. Since deterrence is achieved only when an officer is as aware of the consequences of his illegal conduct and the inevitable discovery factual scenarios he cannot so calculate, the court concluded that no deterrent benefit is achieved by suppressing evidence that likely would have been discovered in any event. If, however, the officer does believe that the evidence will likely be discovered by legal means, he has no incentive to shortcut the legal method, presumably because of the danger that suppression will result. In the court's view, the fear of departmental discipline and the possibility of incurring civil liability also discourages police officers from using illegal shortcuts. This explanation of why it is irrelevant to consider the possible bad faith of a police officer in applying the inevitable discovery doctrine reflects a skewed view both of the need and the means necessary to discourage purposeful police misconduct, as well as a surprising naivety about law enforcement in general. As the court noted, an officer contemplating illegal conduct to acquire evidence will likely be unable to judge whether that same evidence will inevitably be discovered by illegal means. This assertion, while possibly valid, is largely irrelevant because of the court's misleading use of the word inevitable. The court assertion makes sense only if the word inevitable is used in its dictionary sense, that is, incapable of being avoided. Later, within the Williams opinion, we learn that the court's use of inevitable discovery doctrine really means that an officer needs show only the likelihood of discovery by a preponderance of the evidence. In other words, when contemplating the use of an illegal shortcut to obtain evidence, an officer will know that illegally seized evidence can be saved if a judge can be persuaded that it was more likely than not that the evidence would have been discovered eventually through other means. When an officer rarely may be in a position to assess whether a piece of evidence will inevitably be discovered, it is far more likely that he will be able to form a reasonable opinion about whether or not the evidence probably will be discovered. If an officer concludes that evidence he's contemplating obtaining illegally would likely be discovered later legally, and acting on this assumption, he chooses the illegal shortcut to obtain the evidence, a decision to admit such evidence would clearly weaken the deterrent purpose of the exclusionary rule. As the court has repeatedly asserted, the exclusionary rule best serves its goals when it is applied to situations of bad faith misconduct by the police. The more purposeful misconduct, the greater the need to deter, and the more effective the lesson for those contemplating future illegalities. I'm going to see exactly where we're at now. We've already been going for a minute, so I'm going to finish this section right here and then break and finish up the recording some other time. All right. So conversely, allowing the use of evidence which is discovered through a deliberate violation of the law, communications, and the police to the for a deliberate allowing evidence which was discovered by deliberate violation of the law communicates to the police the possibility, if not the likelihood, of benefiting from their own purposeful wrongdoings. Quite often, the presence and pressure upon police to conclude an investigation is intense, and the temptation to act without obeying the rules is great. The doctrine of inevitable discovery, when applied without any regard for the purposefulness or flagrant nature of police misconduct, adds immeasurably to that temptation. There may be, therefore, contrary to the court's assertion, much to be gained in a police officer's mind from acting illegally when he believes the evidence is likely to eventually be discovered by legal means. While there is in the police officer's mind a likelihood of ultimate discovery, he can save time and avoid what may be viewed as needless effort by choosing an illegal shortcut. The court's response to this contention is to take note of significant distinctiveness other than the exclusionary rule that acts as a deterrent to police misconduct. As examples, the court cites departmental disciplinary proceedings and the possibility of civil liability. In fact, neither of these significant disincentives has ever been shown to act as a meaningful deterrent to police illegality. Those constitutional violations which cause no physical injury are rarely the cause for police discipline. Civil suits as a solution to police actions are in violation of the exclusionary rule have been largely unsuccessful because of the unlikelihood of actual and significant recovery by the plaintiffs. Imagine, for example, Robert Williams appearing before a jury of Iowans and requesting money damages against Detective Lemming in the state of Iowa for violating Williams' Sixth Amendment rights by tricking him into revealing where he discarded the lifeless body of Pamela Powers. The vast majority of criminal offenders as plaintiffs in such cases are unlikely to draw sympathy or recover significant damages from police defendants. Accordingly, attorneys are unlikely to take such cases on a contingency basis, and hence it is unsurprising that so few of these cases have ever actually gone to trial. In those situations where the officer believes it's unlikely the evidence will ever be discovered except for his illegal methods, a thinking officer might believe he has nothing to lose by undertaking such illegal conduct and hoping he can later convince a sympathetic judge of the hypothetical likelihood of its legal discovery. Thus, contrary to the court's assertion after Williams 2, a police officer may contemplate an illegal method for acquiring evidence and then quite reasonably conclude the illegal method is a worthwhile means of pursuit despite the fact that the evidence would most likely not have been discovered through illegal means. It appears that under Williams 2, the only curb of the use of the doctrine of inevitable discovery is the requirement that the police show probability of discovery by legal means. In the court's view, to exclude evidence that would likely have been discovered eventually through legal means results in a major weakening of the truth-finding process without achieving any concomitant benefit in deterrence. Such a factorless interpretation of the doctrine can cause grave harm to certain fundamental constitutional protections. Perhaps most obvious among these protections threatened by the court's bad application of the inevitable discovery doctrine is the warrant requirement of the Fourth Amendment. Taken literally, the court's opinion in Williams 2 would permit the use of evidence seized in a house that the police have probable cause to search for which they deliberately postponed seeking a warrant. The police could argue that since a warrant would have been obtained had one been sought, as probable cause to search was present, and since the evidence would have been discovered anyway, it should be admissible under the inevitable discovery doctrine. In Secura versus United States, the court applied similar reasoning in its use of the independent source doctrine to save certain evidence seized after a warrantless entry to a house. The Supreme Court has yet to confront a situation, either directly or indirectly, in which it would need to determine whether the doctrine of inevitable discovery can be used to overcome deliberate police attempts to avoid warrant requirements. Both state and federal courts have come to different conclusions as to whether evidence seized without a warrant should be admitted under the inevitable discovery doctrine. Significantly, the post-Williams cases admitting such evidence have taken a view of the inevitable discovery doctrine similar to that proposed by the court in Williams 2. Since ultimately the evidence would likely have been discovered through legal means, the police should not be unduly punished for their failure to obtain a warrant. The danger of such thinking is that it reflects nothing less than a direct attack upon the principles behind the warrant requirement and the Fourth Amendment. The purpose of the warrant requirement of the Fourth Amendment is to ensure that magistrates will be interposed between the forces of government and the individual suspects. These magistrates are charged with the responsibility of forming their own opinions as to whether probable cause exists prior to the time that the government is permitted to intrude into those areas protected by the Fourth Amendment. Post hoc judicial determinations of probable cause in situations where warrants are clearly required result in an abandonment of the magistrate's role as a buffer between the state and its citizens. Applying the inevitable discovery doctrine to warrant avoidance situations as a matter of course would permit police to enter, search, and seize based on probable cause alone, since they can demonstrate later that a warrant could have been attained. There would be no reason for the police to engage in what is widely perceived as the burdensome requirement of obtaining a warrant. Under such approach, if there is not sufficient evidence to constitute the probable cause, no warrant would have been issued and nothing is lost. If there is a probable cause, police can act without a warrant and come back later and show that if they had taken the time and the effort to obtain a warrant, the evidence would similarly have been discovered. Segura makes this post hoc determination easier by rejecting the defendant's claim that the evidence might have been changed in form or been relocated at the time it would have taken the police to obtain a warrant. A literal reading of Williams 2, especially with regards to concerning for ensuring that the police be left in a position no worse off than they would have been absent of illegality, would seem to compel the admission of such evidence. Because Williams 2 does not deal directly with a warrant situation, the door is open to interpret the inevitable discovery doctrine in a way that does not have this detrimental impact on the warrant requirement of the Fourth Amendment. For example, courts could require for application of the doctrine that some effort to obtain a warrant be underway at the time police illegally entered the house in question and seized the evidence. Such a limitation of the doctrine would be consistent with the factual situations in Williams 2, where the search for the girl's body was underway at the time Detective Lemming illegally learned of its whereabouts, and in Segura, where certain officers had instituted attempts to obtain a warrant when their colleagues entered Segura's apartment. Some courts and commentators have adopted this approach to the doctrine of inevitable discovery. They maintain that the doctrine should be applied only where there is already in existence at the time of the illegal discovery of evidence a demonstrable process at work which would likely have produced the same evidence. Others, including the attorney who represented the state of Iowa in Williams 2, have suggested that in order for the doctrine of inevitable discovery to be applied without additional requirement of looking into the intent of the police, the government should have to show that the hypothetical legal discovery of the evidence would have occurred through an investigation entirely independent of the legal discovery. Thus, where there is a race to the evidence between an investigation involving illegal piece methods and an independent legal search, the fact that the illegal actions actually led to the discovery of the evidence would not result in suppression if it could be shown that the lawful investigation would likely have uncovered the evidence eventually. Again, the application of this limited form of the inevitable discovery doctrine would be consistent with the result in Williams 2, since the systematic search that the court concluded would have eventually led to the body discovery of Pamela Powers was conducted independently of Detective Lemming's interaction with Williams. Under this theory, evidence which ultimately would have been discovered legally through the same process that in fact led to the illegal discovery of the evidence is characterized as dependent and is treated differently in examining its admissibility. In such situations, the purpose for the police offering a hypothetical independent source of discovery would only be to avoid suffering the consequences of their illegal contact. In fact, they then would benefit from their legal contact. Before the court is asked to cure the illegality and reconstruct the investigation along hypothetical legal lines, the theory requires a close examination of the need for deterrence in such situations. Specifically, factors such as the bad faith of the police officer and the flagrancy and the nature of the illegality are relevant in determining whether the exclusionary rule requires suppression of evidence if it is discovered through those means. All right. We'll stop right there. If those following at home, we're now at page 340 of the Dickinson Law Review, Winter 1988 publication. About 2/3 of the way through this long law review article. But it was good. Thank y'all. I guess our mods fell asleep, so it's okay. I hope you enjoy the Fourth Amendment and law journal articles. Have a good legal education. God bless. Good night, folks.